Welcome, everyone. I'd like to welcome everyone to the fall semester Agora lecture. My name is Ryan Front, and standing beside me is my fellow organizer for tonight's event, Alex Visayas. We are honored to have Catharine MacKinnon deliver this semester's Agora lecture, titled Sexual Assault and Inequality, Critique of Consent. Before we introduce Professor MacKinnon to speak, I'd like to briefly talk about the Agora lecture series and its mission. Alex and I came to Brown extremely interested in political theory, and that's the way we met. Some of our favorite and most edifying moments at Brown have been discussing issues of political theory with our friends and classmates. Recognizing this, we set out to build a lecture series that would offer an organized place for these discussions, bring notable political theorists to speak about different normative issues. To this end, the mission of the Agora lecture series is to promote awareness and student interest in political theory through lecture events like this. I would also like to thank a few people for helping to make tonight's event possible. First, I'd like to thank Allie Laughlin, the center manager at the PPE Center, for helping to organize tonight's event, Professor Emily Scarbeck for her advice, the PPE Society, and the PPE Center. And of course, we thank Professor Catharine MacKinnon for speaking tonight. I'll now turn it over to Alex to introduce Professor MacKinnon.
Thank you again for joining us this evening. Catharine A. MacKinnon is a lawyer, teacher, writer, and activist on sex equality issues domestically and internationally. She is the Elizabeth A. Long Professor of Law at the University of Michigan, and from 2008 to 2012 was the first special gender advisor to the Prosecutor of the International Criminal Court. She has been the James Barr Ames Visiting Professor of Law at Harvard Law School since 2009. Her numerous books and articles traverse a wide array of issues, including prostitution, human trafficking, and much, much more. Her books include Sexual Harassment of Working Women, Feminism Unmodified, Toward a Feminist Theory of the State, Women's Lives, Men's Laws, and most recently, Butterfly Politics. For tonight's lecture, Professor MacKinnon will explore the inherently unequal nature of consent as enshrined in domestic rape law. Following the talk, we'd like to open up the discussion to everyone here with a Q&A session where you can ask Professor MacKinnon about her talk or any other topics of interest. With that, please join me in welcoming Professor MacKinnon to the stage.
Thank you so much for coming, and to everyone who's invited me. I always look forward to coming to Brown. I've given a couple of other talks here over the years, and the intelligence and vibrancy and creativity of this student body, I'm sure you're aware of it, but probably you don't have quite the comparative perspective on it that I do. It's very distinctive, and so I feel especially pleased and privileged, really, to be able to be here and talk with you about this. There is a published version of the ideas that I'm going to be discussing with you. I have never given this as a talk, so this is its maiden voyage in the real world, and it also makes me especially excited and happy that I'm going to be able to hear what you think, how it strikes you, how it resonates with you or doesn't, the things in it that are, that work for you, what doesn't. And, it's part of a whole set of ongoing legal, political, lived initiatives. So the fact that, there is a previously published version doesn't mean it's done. I'm one of these people who doesn't move on, as it were. I stay doing everything I've ever done and, just keep doing it in different ways. So I really look forward to your thoughts on all this. The point of departure here is my observation that consent, the term, has become in the last few years something of a holy grail of legal, political, and also desirable sex, all the way from popular press, actually a friend of mine gave me once a pair of panties, underpants, that says on the relevant front lower part, "Got consent?" question. I had an interesting conversation with her then about whether she consented to sex with her husband. And she gave me the most befuddled look and just said, no. Okay, keep that in mind, because that's exactly what I'm about to talk about. It's like when it's real, when it's passionate, when it's enthusiastic and welcomed and you really want to be there. We consented is not how you call it, okay? All right, so nonetheless, it's become this holy grail from popular press, many feminist commentaries, a lot of Title IX trainings that people strenuously attend and deliver, and also in the recent ALI Model Penal Code on Sexual Assault. The ALI is the American Law Institute. It's a elective body that creates legislation that legislatures can then model their laws on. So it itself does agree to whole model provisions, but it doesn't pass them for any actual application. It offers them then to other, to legislative bodies to use. And also, the word consent appears in the federal law on intimate visual depiction that came into effect much below the radar on October 1st, just this last. In addition to lack of consent as an element in the law of rape, or sexual assault, as it is often also called, rape is generally defined in the United States as sexual intercourse with lack of consent, but also by some form of force, typically, but not exclusively, physical force. If you want to see some quite stark distinctions in the law of rape, the United Kingdom's law is exclusively consent defined and doesn't have a force element. On the other hand, if a lot of force was there, that can be used as evidence that consent was absent. And similarly in France, it's a basically force-only law. At the same time, it has an element of coercion, so if you want to negate the coercion, a person who's accused can show consent going to it. So they are distinct, but they just locate the same elements in different places. So I'm going to offer thoughts on both of these elements, but my thoughts will emphasize consent through a sex equality lens. To start out on definitions, the Oxford English Dictionary defines consent as to voluntarily acquiesce in what another proposes or desires. Black's Law Dictionary, actually some friends of mine thought, how great, we finally got a whole dictionary for black people. Nope. Person's name is Black. Black's Law Dictionary defines consent as, this is another definition, voluntarily yielding the will to the proposition of another. Okay, these are standard accepted definitions. The ALI defines consent as willingness to engage in a specific act of sex. This isn't all that different from, by the way, Blackstone's definition of rape as with force and against her will. It just, flips the willingness definition a little bit, but it works out essentially the same. And this willingness can be expressed according to the ALI. I'm actually on that committee and a member of the ALI. How do I put this? They didn't listen to me very much. But then it turns out as I read the finals, some things actually did shift around some amount, but, they didn't do what I'm about to say. So this willingness, according to them, can be expressed or it can be inferred from action or inaction. They do say that saying no or stop or don't establishes lack of consent. Like news. Neither verbal nor physical resistance is required, so there's no resistance requirement to show lack of consent. But, and this is what they added at the very end and really flipped out a lot of people, lack of resistance may be considered as going to whether consent was present, along with all of the other circumstances involved. So, in many current contexts, a series, I have noticed, of prefatory words have been added to consent to either lock in or expand or specify its meaning. These words include freely given, voluntary, autonomous, conscious, positive, chosen. Nobody else has listed these things. I think they're fascinating. Unequivocal, and most recently, affirmative. Rejected, by the way, by the ALI in favor of its willingness standard. Interestingly, the ALI does have specific provisions against particular acts of sexual assault, such as of a vulnerable person or by extortion. And then what they do is they say, if you've proven all these vulnerabilities, then you don't have what is called effective consent, which I actually take a little bit of pride in because it's a word I used in my article. Consent cannot be effective when da-da-da-da-da. So what they did is they took out everything they felt really persuaded by, like as in vulnerability and extortion and so on, and made those wholly separate things, and then said if you show that stuff, then consent is not effective. The intimate depiction law that we just got uses the terms affirmative, conscious, and voluntary authorization is what has to be given in order for an intimate depiction to be legal under that and some other requirements. And it adds in addition, free from force, fraud, misrepresentation, or coercion, which amounts to a sex trafficking type of definition of the materials that they're saying are prohibited online. Now, these various terms reveal or suggest that the meaning of consent all by itself is not adequate, is insufficiently specified anyway, alone, or unsettled, or incomplete, or, I think, in need of some creative rehabilitation to get it up off the floor from the OED and the Black's definitions, the yielding business, the acquiescence notion. These words all attempt to cushion somewhat some of the known effects of the definition. Now, my critique of consent, which is through a lens of gender inequality, is actually more fundamental than is adequately addressed by any of these prefatory words. I give them to you, though, because obviously people have noticed what I've noticed, and they're trying out there. They're trying to make consent be better than what it actually is. And so now I'm going to talk a bit about the ground of what it actually is. And for me, this begins with the observation that in application in the criminal law of sexual assault, consent, when, as either negating an element of the crime or as a defense, depending, and I'm talking real cases now, covers territory from real desire, which you virtually never see in an actual rape case, but they keep calling it that. So desire to despair, to defeat, to dissociation, to death. All of those have happened in real cases and have been called consent. Therefore, it was sex, not rape. There are examples that range from acquiescence to frozen fright to destitution, including in prostitution, where the money is supposed to be consent but is actually a form of force, to white supremacy, in which people assume that if they're sexually assaulting a woman of color that no one will believe her, to lost fights in the back of parked cars, to threats short of death and maiming, such as threats of firing or to give someone a low grade. By the way, that's why sexual harassment law was created. Having done it, I'm here to tell you, rape law doesn't work. That's why sexual harassment law was created. Or reporting someone's immigration status, for example, which has, until this ALI recommendation, but nobody's passed that law yet, has always been threat to do that, have sex with me, or I'll, turn over your whole family to the ice. No, that's not a threat that's sufficient to overcome consent. If you then, in order to prevent your family being, turned over to the immigration authorities, that's called consent. That's not called not consent, okay? Or insistence on condom usage in order to prevent getting HIV. That was called consent. Or submission due to wanting to continue to study with one's teacher, which I think is absolutely heartbreaking. That's called consent. At least it was until it became sexual harassment. But it isn't called rape in the criminal law of rape. All the way to passivity, resignation, lying there in order to minimize further injury or risk of even worse harm than is being inflicted. All of that has been called consent for several hundred years. This leads me to the observation that consent as actually applied in the criminal law has been about being rolled by power, basically. And also that its legal reality fails to fit its social reality. The essence, or one can observe actually, that the presence of consent in none of these examples actually makes an interaction equal, speaking of gender inequality. It makes it tolerated or the less costly of alternatives that are out of the control or beyond the construction of the person who so-called consents to it. Put another way, the concept can be observed as being inherently an unequal one, simultaneously one that silently presupposes that the parties to this interaction actually are equals, although this is never discussed, whether they are or not. So by contrast, when rape is seen as analytically a gender crime, which builds in an awareness of substantive structural hierarchy, including principally here, of the inequality of men over women, and this includes, obviously, trans women, men over other men, including all men, including trans men, men over children, without regard to sex or gender. And those, in fact, are the rough statistical categories in order of frequency, prevalence, and incidence of occurrence. That is, the highest numbers are men over women of all kinds. The next highest numbers are men over other men, and the next numbers are adult men over children of both sexes. And what you notice from the standpoint of analysis of gender inequality is that the sexualized gender dynamics of masculinity, regardless of sex, over femininity, again, regardless of sex, and actually, in some instances, regardless of gender as well, although, those are both gendered terms. Once you see the mapping onto these facts of those gendered regularities, a whole number of other features just jump out and grab you by the lapels. You notice, first of all, that the criminal law requires that the prosecution prove non-consent, which means that an act of sex, which a complainant has to have said occurred or they wouldn't be there, is presumed meaningfully consensual unless it is proven not to be. Now, this joins up with a social burden of proof in which women in particular are sex. We are supposedly socially for sex. We are actualized by having sex. And it also, that also has to be overcome. The social burden of proof that women have entering into a challenge to say, having said that someone had raped them. This is 1,000 times worse in white supremacist cultures like this one, the United States, for women of any color, with very specific forms of denigration built into the social burdens of proof that they need to overcome, along with then this legal construction. Then, with the consent model, you notice that whoever, this is the second thing you notice, whoever initiates the act of sex in question is permitted and envisioned tacitly always to choose the time, place, manner, act, etc. Of whatever sex you're talking about. They are, in other words, acting. The person who consents or not is the acted upon person. This builds in heterosexuality's dominant stereotype of active-passive, which is conventionally man-woman, but much more broadly gendered in terms of masculinity and femininity, which do not stick in any exclusive way to being male-bodied or female-bodied. And it can be any sex or gender. It is the dominant sexual model, without regard to the bodies of the people. Its model is doer and done to, like a medical incision. Consent then turns into something like tolerance of a boundary violation. All right? I was fascinated to read Peter Weston, a legal scholar, who defines consent as consisting of, quote, all instances in which persons are found or desire to acquiesce to or choose for themselves. We're doing all right so far, pretty much, but now guess what? What other persons do to them. Okay? So you've got a doer, done to model of sex built into the whole idea of consent, no matter how many prefatory words you put on the front of it. Then, and this is the third point, because consent is intrinsically subjective, although laws can and often do require some kind of external expression of it. I mean, it just won't do, to send someone to jail because a woman is like lying there looking at the ceiling, thinking of England and counting the cracks and hating it and saying nothing at all. Okay, so they, tend to look for some external expression of disinclination. It then becomes the reason that the alleged victim is put on trial. That is why the focus is relentlessly on her. and in particular, what she does with her body, on what she was thinking, on what her dress or prior statements or prior experiences were or mean. Why did she wear this? Why was she there? Rather than on him, which actually one was thinking he was on trial, you had thought. But that isn't what happens. But this is why. In other words, they're endlessly looking at, what she is doing with herself and in her head, rather than what he was doing with his power. What he was doing at the time, or their relative status, or what enabled him to get the drop on her, or him, or them. What disabled their resistance or expression of disinclination, which can also be restrained. So this effect is accentuated because a sex act can be forced in law, but also consented to. And until I came along and said I thought that was redundant in the weirdest way, in other words, the reason that force is there is because consent isn't there, and however, the fact that sex can be forced but also consented to, and there are a whole lot of cases that actually do this. This is called, the so-called rough sex defense is a version of this. There's whole sets of versions of it. But the basic structure is that structure, right? It builds into its usual definition the notion that women desire forced sex. The idea that we want to be forced to have sex. And this whole thing also requires prosecutors prove a negative, which is point 4. It requires them to prove that something wasn't there, rather than that something was. In other words, whatever he was doing, and I say he because it is generally a man, but not exclusively so, but in the 99 plus percentile, so it's an overgeneralization. But rather than focusing on what someone was doing or what the circumstances were, you're focusing on having to prove something wasn't there. That is, her consent was absent. So at this point, one may begin to wonder, where did all this come from? I certainly did, and I noticed, couldn't help but recall, having actually a degree in political science and my field is political philosophy, that the concept of consent is given really its fullest articulation in the history of political philosophy. In England in particular, 17th and 18th century, we're speaking now of the dead white male liberal pantheon here, and some of it, moving into the 19th century as well, and I don't think people have gotten past it yet. What happened was, after the demise of the divine right of kings, the question of what made rulers legitimate created a panic of a couple hundred years and a lot of libraries full of, what makes the state legitimate, okay? The central answer that they converged upon was consent of the governed, including tacit consent. So how do we know that people consent? How did they find out? How did they offer to us knowledge of consent to rulership? 1, the ruled were silent. 2, they were there. 3, they were said to benefit from the government. 4, they did not raise armies and fight back. Now, is this like starting to ring bells at all, in your mind? I can't be sure which came first, although a lot of good historical legal scholarship and philosophical scholarship shows that there's a lot of public and private consent stuff that flows together. And of course, the public and private distinction is nonsense anyway, but by this I mean they think they're talking public when they're talking about the rulers and the ruled, and they think they're talking private, even if it's criminal law, when they're talking about men and women having sex together. In any case, the notions of consent have been shown to flow together somewhat here. But she didn't say no. Why doesn't she leave? She really wanted it. She didn't resist. I mean, all of these are really stunning parallels. Now, regulating our sexual lives on a ruler-ruled paradigm does serve to illustrate, even highlight, that this is not what a lot of us have had in mind by sex equality, far less sexual liberation. And despite all of this, law continues to effectively assume, as I mentioned, the equality of the parties to sexual relations while ignoring the whole structure, the whole question really, of how a person can be free in sex when they are structurally unequal in society as a whole. This does not seem to bother the world, this question. I mean, there aren't like endless papers on it. There aren't conferences. There are not whole libraries on this subject at all. It isn't even mentioned, you know, in these endless discourses on freedom. How can you be free when you're unequal? You know? And now, let's talk about sexuality. But no. Now, of some legal interest here is that the 14th Amendment to the Constitution, which, you know, stuck on with spit and a prayer after the Civil War, the last one, the Civil War, which requires equal protection of the laws, that was specifically written to address state laws that discriminate. And it has been interpreted to apply to sex. Tenuously, isn't in the text, wasn't meant at the time. As a matter of fact, it was meant not to apply to sex at the time. Don't let anybody tell you different, unfortunately, but that's the case. And only people who thought it was going to apply to sex were the people who voted against it. So anyway, it does. And also, Fifth Amendment due process applies to federal provisions as well that address issues of sex in the criminal law and sexual assault, which, for example, have to do with military, with the extent to which Native people still are not sovereign over their own Indian country. They're still governed by federal law. I'm saying Fifth Amendment due process has an equal protection component, and so equality, including sex equality, which has been recognized there, should apply to all of that. And it applies to not any of it, not once, not ever, except when there's a facial distinction on the basis of sex in a statute that says, say, only men are guilty of rape if say they are over age and they have sex with someone who's under 18, for example. Statutory rape laws, some of them are sex specific. They've been upheld. That is when the Supreme Court will look at it because it says sex on its face, and also, one might note, it disadvantages men. And they actually upheld that. So, by contrast to all this, the law of sexual harassment in employment in particular, but also it's been applied in education, and this is civil law now, not criminal law, does take a sex equality approach to sexual assault. We did that on purpose. Did it civilly, did it in those areas that criminal law doesn't call rape when it is. So there's a lot of rape in the law of sexual harassment. It's just called sexual harassment. And what you find there is there is no consent standard. The first case in which we litigated this, and this was a client of mine in the Supreme Court, we established that consent, including this term voluntary, didn't belong in an equality law. And what we put there instead was the term welcome. So you might be wondering, and sexual harassment law does require that the person who brings the claim say that they didn't welcome the sexual incursions or initiatives or pressure or what they're saying was done to them. Sometimes courts want to see that they made clear that this wasn't welcome, but usually, I mean, what is fascinating to me about it, I mean, first of all, I didn't think this court was going to understand any distinction between consent and welcomeness, but they did. And what is fascinating about it is that once you put a sexual assault in some kind of hierarchical context, even if there was no indication of disinclination, and there is no proof that she initiated the sexual contact or interest, courts are done. They're out of there because she says, look, usually it's she, but it's also men, gay men including in particular, I didn't, or men people think are gay, and then are, attempting to, be sexual with them, men generally. The courts just generally look at that and say, oh, I understand why she didn't tell him she didn't want to do this. And usually what people do is they minimize it, they avoid it, they laugh about it, they try to move around it, they are evasive, and they just never act interested. And that's enough. Well, in rape, it isn't enough. You don't have a woman in a rape case ever acting interested. You don't ever have her showing that she wants to have sex in any real way. You don't ever have her, there is literally no indication of, desire, pleasure, anything, in these rape cases. And yet consent is what is found. However, if you're looking for welcomeness, you want a little enthusiasm, please. And the fact that it just isn't there has been something, shockingly, that courts can understand. Maybe I'll just be a little graphic about this distinction, since people get confused about it. All right, so say the police come to your door. They're and you're like, whoa, and you've got one of those little chains on the thing, but you open it and the chain is holding it shut and you look, and they're like, no, we have a warrant, we want to gee, can I see the warrant? No, you can't see their badge. Like, what's the deal here? They push through the door, they roll over you, they search your place. It's called a consensual search, all right? Welcomeness, on the other hand, you hear this at the door. You go to the door. You look out the little witchy there, and you see, oh, it's Adam. I haven't seen you for so many years. You open the door, right? Adam, come on in. I am so thrilled to see you. Come in, right? Big hug. Welcome, come on in. It's like all the difference in the world. I hope that is clear. A little bit of choreography here. So I think that the idea of affirmative consent is trying to get there. However, what it's doing is essentially backing consent into enough activity on behalf of the person who is the supposedly consenting person to transform what is a passive acquiescence model into something more like mutuality. So trying to, they're trying, okay? But it's very upstream. What I think it also does is that it promises power to women, this affirmative consent idea, in sex and in court. I've said a little bit about what is meant by it in sex, and if people are respecting of it, it can work. It can. The thing about it in court is that it suggests that what the woman really subjectively felt and what she actually wanted, once she says that in court, that it will be respected and believed. There is absolutely no basis in reality for this, that what women said will be found credible in this context. There really isn't. And the other thing is, while it's a big improvement to have yes be required for yes, and it's a big improvement certainly on no meaning yes, there is no talismanic wantedness quotient that goes along with the saying of yes. Women know men want women to want to have sex with them. Therefore, they say yes, whether they want to or not. So, the way, I'm not saying that's fair to everybody or anything. I'm just saying that is the state of inequality still. And, the fact that that's the case, therefore means that not only can yes be coerced, and certainly is. Pornography is full of yes. And it's full of women who have no desire to be there doing what they're doing and have done to them what's being done to them. But yes is all over it, because the pimps who make it know the viewer, who is generally a man, wants to see her wanting it or desiring it or expressing affirmative for it. So, if inequality can coerce a yes, then affirmative consent doesn't solve the inequality problem either. And I just think that the idea that the criminal justice system is going to believe the woman as to her state of mind on her testimony alone all of a sudden is so unlikely. Other than for really bad reasons. For example, under white supremacy, it seems that one can better, if one is a white woman, one can better convict a man of color of sexual assault that he didn't do than women of color can convict anyone, any man in particular, of sexual assault. In other words, there's a false hope being held out around this affirmative consent idea, I think. And it's really extremely, it's regrettably unrealistic, but a lot of people have bought into it. So my proposal is to remove consent entirely and to redefine force to include all the relevant forms of inequality that are what make sexual assault able to be what it is. I think the definition of sexual assault, instead of endlessly trying to tweak consent to make it work, the way an equal vision of sexual reciprocity works, that it should begin with changing the ways that people take advantage of the circumstances of inequality in sexual assault. And this follows on some international work and precedents also. Specifically, when sex inequality itself is deployed as a form of force, as a form of compulsion, is, I think, needs to be embodied in law. I'm proposing a definition as follows: that sexual assault or rape is a physical invasion of a sexual nature under circumstances of threat or use of force, fraud, coercion, abduction, or the abuse of power, trust, or a position of dependency or vulnerability. Now, this psychological, economic, other hierarchical forms of force, which include age, mental and physical disability, immigration status, sex, gender, race, class, sexuality, caste, all of that, when deployed as forms of force or coercion, not simply being there, not just being there, all right? It's not enough. But ways in which they are used to coerce people in the sexual setting would be forms of compelling people to have sex in particular interactions, and would be specifically recognized as coercive. Conditions like drunkenness and unconsciousness, which are pretty well recognized in a lot of places these days, along with other forms of incapacity, such as, roofies and all the way that is happening, would be positions of vulnerability, putting a person into a position of vulnerability. I mean, as it is now, a person can be unconscious and be said, and you can't prove non-consent because she couldn't not consent because she was out cold. I mean, this is craziness. All right. Fraud also is a strong form of deception. And expression of disinclination, I think, would be among the, no, don't, stop, etc., would be the kind of evidence that these listed means were used in order to secure compliance. In other words, if there's compliance over and above somebody saying, no, stop, don't, it's because there are forms of force that are not only physical, but on my list here of hierarchical social inequalities that have been used to compel the sex. So again, I'm saying the exploitation of inequalities, they're actually direct use, not merely the fact that they are there or that they contextually existed, but are actually directly used, would really need to be part of how this is done. Now, what everyone is all in a panic about, I mean, it's not too extreme to call this a panic. At this moment in time, I'm not saying you all are, but having sort of been around the block on this subject for a while, the actual desperation that arises at this moment in time in the discussion is how can we have heterosexual sex? How can it take place under conditions of inequality, yet all of it not be unequal? Now, what's great about this is that it, first of all, exposes the real difficulty people have in imagining equal sex, which turns out to be a really hard problem. What I'm trying to say is that when a sexual interaction is equal, first of all, consent isn't needed and doesn't occur because there is no boundary transgression to be redeemed by it. Okay? So that's what you have first. I just call that sex. Okay. And when a sexual incursion is not equal, actually no amount of consent makes it be equal. One of the great things about equality law is that nobody thinks that consent, you can't consent to inequality. It doesn't, I mean, people do all the time. For example, you're paid unequally. No one says it makes your pay be equal that you took it. You know, that you got paid those peanuts. It doesn't make it equal. It doesn't change it. So what I'm saying is consent doesn't redeem something, doesn't redeem unequal sex from being violative either. And I'm calling that sexual assault. But I think that if sex is equal between people who socially are not social equals, it is because it is mutual, it's reciprocal. People respect each other, they trust each other. There's real desire there. As well as sometimes people are hoping and sharing a determination to get past these realities rather than they're facing them, not denying them, and they're swimming upstream together against all of this. This is doable. It's not one-sided acquiescence. It's not unilateral obeisance or exchange of sex in some kind of transaction. It's rather sex for sex, not sex for any other kind of treasure. It's its own reward. You know, I used to think that I was making this all up, you know. And then I read a definition of actually prostitution in Namibia, and it was contrasted with sex, in which it said sex is that the consideration for sex is sex. Consideration meaning comeback, you know, like what you get out of the thing. And I thought, oh, wow, somebody knows that there is such a thing as, you know, sex that is its own reward. How about that? Having been told that, you know, this is impossibly naive at this point in time. But what I think is that vision of it is what makes it be intimate, interactive, moving, compelling, communicative, like warm, personal, loving. And if all that seems like complicated or, you know, a bit extra heavy, I think sex equality in society has a real chance to make it simple and light and normal. And that it is inequality of power that makes it seem like some kind of grim political project. I'm not suggesting, you know, you like have to go out and have sex and try this, you know, for political reasons. I'm just saying that it seems complex and distant because of inequalities of power that have gotten all over it. So the point of this revision of rape law is that the most powerful people, rather than the least powerful people, are the most legible to this law, by contrast with what rape law has done up to this point. The potential perpetrators under the law are highlighted in the same way that they are in life, as opposed to the total reversal of that, which is what we have right now. And all their forms of power that coerce sex are explicitly recognized, with the goal of making sexual assault be truly exceptional for a change, and finally extinct. Thanks a lot. Like 40 minutes, right?
All right. Thank you again, Professor MacKinnon, for the excellent speech. We're going to now transition to the Q&A portion of this talk, so feel free to go to either of the microphones in the two aisles. Any questions are welcome related to the talk or any other topics of interest. Thanks.
So that's all like a really heavy download, you know? You might want to like take a couple minutes to take it in.
Hi,
Hi there.
my name is Michael.
Hi, Michael. That should come up higher. You shouldn't have to crouch like that.
Oh, cool. Thank you. I watched a show on TV called Law and Order, SVU, and I'm wondering, when it comes to the information that's being presented on a show like that, especially when it comes to heavy topics like the one you discussed today, what role does a show like that have in presenting that information as accurate as possible so the wider audience could put conversations like this into multiple spaces?
Yeah, now that's interesting. I'm a television resistor.
Okay.
You know, the only thing I like very much is Anderson Cooper.
Yeah, he's cool.
And also Don Lemon. And so, I don't have a television. And so, I don't know what Law and Order does. But I do read People magazine and hear from people a lot about what kind of sort of mainstream media out there is presenting. And, you know, the people who create those shows call themselves the creative community. And it's been my experience they're usually at least 10 to 20 years behind anything that certainly I'm ever doing, if not more. At the same time, there's some really like good people there who have moved some issues, I think, really effectively at like the transparent business, that show, like, and I think it's particularly helpful, you know, to have, you know, trans actors in those portrayals, and to normalize something that is normal, but people who don't have trans friends don't know that. And so, you know, that kind of thing gives people a point of contact. And I think similarly, there have been media moments that have done a lot, you know, for this subject. One thing I would just observe, which is not exactly what happens in media, but rather that, you know, the way the Me Too movement began and took off, and then, you know, millions of women all around the world started talking about, you know, sex in the context of inequality of power. That's really what that was about. That is still even, and is, you know, sort of boomeranging around the world still. And it seemed to me that women in entertainment were the perfect people to be the ones to kick that off, because they are the ones who have to play the roles that are like what is in Law and Order, that often, you know, present both unrealistic things from their own lives, but also in order for them to continue to be able to work and to be sexually objectified out there, they have had to do what they said they had to do with Harvey Weinstein and a whole array of other men. In other words, they are perfectly positioned to be the people to explode both the industry notion that they are some kind of, you know, that they have perfect lives just because they're famous and people know them through characters they play. I actually know a lot of these women, and it just never occurred to me that people in the world would think they knew these women because they had seen them play characters on screen. I mean, it's like, hello, it's called acting. okay? And they are good at it. That is why they are there. You know, you don't learn anything about who they are from the characters they play. But there's, you know, this like endless sort of link up and fascination and around that. And then suddenly, you know, these women are coming out and saying, you know, I had to get raped repeatedly in order to get these parts. Or they told me all these other women were, you know, complying with this, and if I wanted to, this is just the way Hollywood works. It's called the casting couch. And, you know, suddenly, you know, venture capital had a casting couch. Suddenly, you know, academia, especially philosophy, had casting couches. Suddenly, I mean, it just going all, you know, and it broke it open. So, you know, I just... from things I do know something about, which are, you know, the lives of women, as opposed to what is in Law and Order. Those are thoughts I would offer to you. If you want to follow up and say something more about Law and Order, feel free. Okay.
No, not at all. You answered it.
A lot of times that stuff is not legally accurate, and that's one of the reasons I can't bear to watch it. But the real reason I can't bear to watch all that stuff is, to me, it all looks like pornography, except they stop short of having the explicit sex. I can't stand it. It's just, you know, like MTV just did it to me. You know, once that was out, I mean, it's like, okay, I've seen all this before. Now is when, you know, he's going to do this to her. Now is when this is going to happen. And now is when the animal is going to be, and da-da-da-da-da. You know, it's just, it's pornography short of the explicit sex. So, and I'm supposed to be entertained by it, you know, and I'm not, so.
Thank you. Appreciate it.
Yeah, go ahead.
Hi, my name is Michelle.
Hi, Michelle.
I had one question about, so Brown has a lot of programs on campus that do like peer education regarding consent and like bystander intervention and stuff like that. So with your new model, how would you propose that like college campuses remodel these kinds of things to better fit with what you're proposing?
I would say, you know, dump consent and start thinking about welcomeness. You know, it's a completely different model. I think it's what people are trying to get at, especially younger people, you know, in all these trainings. But it doesn't, you know, there was actually there's a couple of examples. Margaret Cho, for example, who's a brilliant comedian, has a riff where one part of it she says, she goes into this long description of all the sex that she had, even initiated, that she didn't want, just to get it over with and to have, you know, the guy stop either bothering her about it or to sort of reduce the passive-aggressive stuff going on, or just to have a smoother relationships. And, you know, she just talked about it as soul-destroying. I mean, she didn't want to be doing this, you know, but he did. So, and, you know, there's a lot of discussions about marital rape that talk about, you know, routinized sexual interactions that in which the women anyway, I mean, there aren't endless discussions of men saying, you know, we have sex a lot and I really don't want to do it. Maybe that exists, but it isn't out there. What's really out there, beginning to be, are a lot of discussions of women saying they have sex a lot and they really, under conditions that they don't control and don't want to have. You know why? Everybody is flipped out about Dobbs. Do you know why? Okay, this is it. About so-called losing the abortion right, which, by the way, we lost in 1980 when the Hyde Amendment was passed and all the women who can't pay for their own abortions lost federal funding for it. Okay, but there was not, you know, massive demonstrations in the streets and the world hadn't come to an end, apparently. It has now. You know why it has? Okay, it's not because of the medical issues, which are extremely serious, and the ectopic pregnancies and the threats to life that can come up at the end, and, you know, I mean, all that's really serious. That isn't the numbers, not even close. You know what the numbers are? They are what I'm talking about. I'm talking about sex that women don't want to have, that they don't control. They don't control the circumstances under which it is occurring. It is happening to their bodies. They know they can't do anything about it. And the only, tiny moment of possible escape they've ever had is knowing that if they got pregnant, they could have an abortion. And now they don't know that. And that is what that's what's happening right now. That is the panic. And nobody's talking about it. So, because Planned Parenthood hasn't wanted to hear about sexual coercion. They're allergic to it. Abortion has been a pro-sex right. And it's one of the reasons men have been in favor of it, to the degree they have, actually. And the consequences are things they don't have to bother with anymore. But now they do again. And, other than the headache that I might get pregnant, was taken away as a reason for not having sex. And it's back. But having sex under conditions where women's bodies are not being paid attention to is not sex that women control. And it's not because women are so super up for, let's go do it, and, which is what the right thinks, and ignoring, it's not that women are overwhelmingly, ignoring the physical risks that we're taking because we are so into having sex. That does sometimes happen. And it isn't just contraceptive failures either. Although that does sometimes happen. What I'm talking about, these are the real numbers. And, why this is such why, the world is coming unglued as a result of this, suddenly. So I don't know, I say welcomeness and, meaningful, effective mutuality, reciprocity, respect, trust. And I'm saying, I don't even necessarily, I'm not saying people have to even know each other. Although it can help, but, if people want to have sex like an indoor sport, I'm not here to say there's any problem with it. But, there's, per se, there isn't. But, there is if the woman is just getting used, and wiped off on and, tossed away more or less, which it turns out in the studies of hookup culture, there's just a massive amount of that. And it is true that women have generally cared more about the relationship qualities of interactions, but men care about it too, It's just they're not supposed to or something. And, they're supposed to be ready to go at the drop of anything. And, there are men who don't necessarily just welcome sex with anyone at any time under any circumstances. They have thoughts. So, and some men don't want to have sex with women who don't really want to be doing it. Newsflash. So, I think building on that, there's a reason that women have faked orgasms for centuries, and it's because it makes men think they've done something. And it's just don't do this stuff. This can be really great, but people got to stop lying about it. And, building in these, this transactional model of, if you don't sleep with me, I'll find somebody who will. Or whatever is the exchange, which is the opposite of the mutuality I'm talking about. I can't believe I'm turning into a sex therapist or something. But yeah, I would suggest that. I really would.
Thank you.
Like the real deal. Hold out for it. Yeah.
Hi, my name is Logan. Thank you so much for your talk.
Hi, Logan. What a nice name.
Thank you.
Yeah, I think you're the first Logan I met, so I'm,
Well, great.
yeah, happy to
Awesome.
happy to hear from you. Yeah.
Well, I think it's fair to say that a lot of the issues that come up on college, university campuses about consent, sexual assault, and rape are reflections of the larger systemic power inequalities that you were talking about. But I'm curious as to whether those inequalities manifest themselves in any specific or unique ways on college campuses, and if there's anything specific that we should be mindful of as college students.
Yeah, they do. In particular, do you have fraternities here? Okay. They manifest themselves in very specific ways in fraternities. And Peggy Sanday has a very interesting set of researches on this subject, Sanday, that I recommend you read. And she finds the homosocial bond among men, both to prove they're not gay and to prove they are masculine, and bond with each other, is often enacted over the bodies of the girls they have at those parties. And often schools only allow the fraternities to have alcohol. Is this one of them?
I'm not sure.
Okay, because I was shocked to find this out. Actually, it really takes a lot to shock me these days. But that one really did it. Only the fraternities, wow, where did that come from? You know, the sororities can't have alcohol. You know, only the fraternities can. So if people want to drink, they have to go to the boys' parties. And, you know, then people drink. And what happens around drinking, among other things, is, apart from, you know, just being a social way that people engage and so on, is that if sex happens and he was drinking, it's not his fault because he couldn't control himself. And if sex happens and she was drinking, it is her fault because she must have provoked it. Check it out. It's just a piece of the brilliant consistency of misogyny. Otherwise, the stuff makes no sense, you know. So that is a very definite place that it plays out. With hookup culture, you know, campuses are where that happens. So I've already said things about that a lot. And if that's just, you know, I mean, if that really is friends with benefits, great, you know, if the benefits are mutual. But a lot they're not. And again, the studies show this. It's just, you know, come over and service me tonight kind of thing. And, you know, there's a tremendous amount of women sexually servicing men still and getting nothing out of it sexually at all. And just to point out, we do not have clitorises in our throats, folks. So, which isn't to say, you know, that kind of sexual interaction can't be part of an ongoing mutual set of exchanges. It absolutely can, you know, but just the servicing bit, you know, on your knees, honey, you know, et cetera, is not what I'm here to be supporting of. So those are two really major ones. And then there are male faculty, which is often great, and, you know, but that can sometimes be a real issue with men students and women students, where, okay, there's a general tendency, of which colleges are only one example, and that is of people who have sexual preferences for people of a certain age to place themselves in professional positions where they constantly have a new supply of people of that age. And so colleges are an example of that. And it's a predator relation. And then there's all the racism that happens in college communities. The structural racism, the denigration of both faculty of color and students, and the sexualization of the way that works. The lack of responsiveness to, I mean, I endlessly deal with young women of color who are sexually assaulted, and the schools do nothing. I can even get prosecutors to do more. I can get police to care more than the school. That's really outrageous, since they are really bad. I mean, you don't want to send someone to the police, but sometimes, they're better. So, particularly with Title IX and those remedies, okay, what I would add right there is the soft version of the process that people have at schools. Often there's the formal process, and then there's the informal process, or however those are divided up with regard to reporting of sexual assault, and then, we'll let you go through it this way or that way or whatever. Beware that stuff, and beware the so-called restorative justice stuff that gets grafted on to the expansion of the informal. Because, number one, it means that they can disappear it. They don't even, if they can get it to be a non-event, they don't even have to report it to the Clery Act reporting as a number, among other things. Number two, this is, girl rolls out of the bushes and reports this to the school, and this, all she wants is for it to go away. She wants to be able to deal with her classes. She isn't even in post-traumatic stress yet. She's in trauma, okay? And so what she wants is, she's thinking that the school leads her to think that it's going to be on her side and take care of it, and she doesn't need a lawyer. And if she knows who the guy is, he does have a lawyer, typically. And so about a year later, a destroyed educational environment for her. She is into PTSD. Maybe she's had a few accommodations, but she's got to deal with the guy. She can run into him anytime on campus. Because you're a community. It was a really good question you asked. I never thought of it this way, but now this is my fourth set of thick examples of an answer to it. It's a community where, unless something's found about him, he gets to be here, and she still gets to be here. So, they don't prevent him from taking the same classes she's taking, and so on. So she's dealing with her rapist on a constant basis. I will tell you that COVID was heaven for a lot of students I know, because they could take their classes remotely. They didn't have to listen to, they didn't have to walk past their rapist in the hall or think that they're going to come across him on campus constantly. And, it wasn't heaven for anybody else, but it just goes to show that, highlights the circumstance. And the restorative justice thing then just becomes a reason that she should not take herself seriously enough to think that something should happen to him for what he did to her, is what it becomes. First thing you do is anything he says cannot ever be used to do anything to him. Amnesty at the threshold. Not, let's consider this, let's talk about it, let's see what we can do here, and then see if you want to let him off the hook. If you're really going to do RJ, you've got to do the amnesty at the front, usually. And, they develop programs generally that are structured that way. You can't expect a guy to say, I'm really sorry that I assaulted you sexually, when in fact he could be prosecuted for that afterwards. You can't do that. You can't do that, to anybody, someone accused of a crime, or, and then have him confess to it and then prosecute him for that under a structure that you've arranged. I mean, no. Okay. So what they do instead is decide to, like, sort of make it go away in terms of playing into femininity, basically, and women not caring about themselves as much as they care about him, and her having the thing a lot of women want is for him to acknowledge what he did. Number one, she knows what he did already, whether he acknowledges it or not. So I'm interested in the extreme importance of him acknowledging it. I get it, and it is a serious thing, but it doesn't make it be real that he acknowledges that it was real already. It happened to you. So there's that. And then they want him to apologize. Now, there are apologies and apologies. I've seen a couple real ones and a lot of unreal ones. You've seen them all on television, the unreal ones. I'm so sorry that you felt that way. I'm so sorry if you were offended by what I said. It's like, it's like not actually taking the weight. The real apology is, I did this. I was thinking I could do this because I thought, whatever, fill in the blank. It was, it's a crime against your humanity. I see that now. I didn't see it then. I should have been somebody then that I wasn't, and I'm working to listen to you now, to become, who I need to be in this world. That sounds like an apology to me. I've heard it once. So those are all school-related intensifications of said issues.
Thank you so much.
Thank you, Logan.
Hi, my name is Minnie, and so my question is really about early childhood or elementary school level education. Beyond the generic, if he hits you, that's bad, you should leave, those generic statements, how do we really help children understand or be ready to understand these things when they're older? Yeah, they need to understand them right now, because a lot of this is being done to them by adults right now, in huge numbers. You know this, right? Yeah.
Yeah. This model, it's very interesting. Like, what people do with age is they say children can't consent, but they never say what they mean by that, or why that would be the truth or the case. And it seems to me that age is almost the only, one of the few hierarchies other than being in prison, and guards and prisoners, for example, which is a recognized hierarchy, an inequality, but they never call it an inequality. But age is a huge one. So, but they never call it an inequality. And I think that, there really is as yet no adequate approach to the sexual abuse of children, period, at all. And, there's like criminal laws against it. They are deemed unable to consent. The real reason is because, you don't have to force a child, if you want to sexually violate them. And children are taught to do what adults, especially ones they love and trust, who are usually the people who are violating them and molesting them, they usually do, they want to please the adult. They usually do what they're told to do. And that's where it starts. I mean, that's where all of this starts. It's where the perpetrators are violated as children, boys, and the girls are violated also as children, and then grow up thinking resignation, nothing can be done about this. This has been done to me since forever. I might as well get paid for it, hence prostitution. And almost everyone in prostitution was sexually abused in childhood previously, okay? Or, a whole range, I mean, not everyone who was sexually abused in childhood is in prostitution by any means. It's just the other way. Most people who are in prostitution were sexually violated. But sexually violated girls are about, we know 35% of, that's the base known contact form figure in the US. And then we find that on any given day, about a third of people who we know were sexually violated because there are hospital records of it don't recall it. So add that to your 35%, because the 35% is in-depth interviews with ethnically matched people and linguistically matched interviews. So they won't remember it. That number won't remember it on a particular day of that interview. So we're talking, in the numbers around half of all of us, to start with, girls. And with boys, the data is not good at all. It is only mostly of college boys because they are a captive population for psychologists to study. And, they consent, of course, to the studies. And it's about a quarter of them. So, which, given they are half the population, I mean, these are whopping numbers. I mean, that is a massive number of boys who then grow up to be men. We don't know what happens to that population. I'm interested in it. No one studied it. Where do they all go? I know the ones who are really good prosecutors and are very determined nobody's ever going to have done to them what was done to them. I know really good fathers, who had that done to them. And, a whole range of people. And then there are the ones who grow up to be the convicted rapists because they're the ones who are in prison. And it's a much, much higher number than is otherwise in the population. In other words, they were sexually abused, and now they're going around sexually abusing other people. So, I mean, it's a close friend of mine who died recently, a woman who is from an Arab country. I was talking to her about this one day, and she said, that she went to schools like the school you mentioned, and started out by walking to the front of the room and asking the children how many of them had been sexually violated, and all the boys raised their hands. And about half the girls. And she stopped doing it because she had no place to send them, any of them. But she found out that the reason the boys were being violated at such a high rate is because they're the ones who are allowed to be out on the street in a conservative Arab community. And the girls were, up to a certain age, more kept at home. So if they were violated, it was going to be in their family, but not, out in the world. And I just give you this, to highlight the problem underlying the question you asked, because I don't think there are any answers to it. What we're in the middle of is more and more sexualization of powerlessness. And I mean, that's the dynamic of pornography. It has taken over the internet long ago. It's by far the most use of the internet. And, you know, the more powerlessness is, that's the model here. And the more powerlessness is sexualized, the more children are targeted. Younger and younger and younger. Because, you know, they are the powerless of our world. And, you know, the fact they grow out of it, you know, doesn't, I mean, out of the powerlessness of being children doesn't mean it ever goes away, as is clear from what I'm saying, and the, you know, the ongoing consequences. So, you know, I mean, I think that there needs to be a lot of receptivity to identifying and not pathologizing families, but identifying children who are being sexually violated by people who see them at school. And there's also a whole separate set of issues around trans kids and non-binary kids, and you know what's happening with them. And a lot of them are being not only massively sexually violated, but absolutely abandoned by their schools in many settings. And their rate of sexual assault is even higher, you know, than other children who are not trans and, you know, identify with the gender they were assigned at birth. So, you know, I think that all a school can do is to try to be receptive to these issues and supportive of these children and, you know, figure out ways, you know, to get what's being done to them to stop. And that includes bullying, which is 99% sexual, in schools, as well as adults who are preying on them in their, you know, in the rest of their lives. And I wish I had a better answer. I'm okay. I'm very happy to hear what people want to ask, and there's a couple of people also on both of these mics, so I'd like to hear from them. And everyone, you know, anyone who needs to leave obviously feels free to leave.
Hi, I'm Flynn. And
Hi.
I just have a lot of questions about how this like conversation revolving consent relates to your work on pornography at large, especially at a time where like language of empowerment is used so frequently, and how possibly this idea of empowerment could be conflated with an enthusiastic yes, or like this idea of welcoming that you mentioned.
Yeah, it can be. You know, I just think it's important for people who understand the way inequality works and the fact that pornography is a branch of prostitution and is a cornerstone of inequality. And brothels are not empowerment parlors, I'm telling you. You know, and you know, I have it on authority of a survivor movement that has grown out of the anti-pornography work that is working worldwide to abolish prostitution through the Nordic model, which is also the equality model. And what it does is decriminalize the people who are bought and sold, and strongly, you probably know this, but other people may not, and strongly criminalize buyers, because they're the ones who are driving the industry. There would be no pimps and traffickers if nobody was buying. And the pimps and traffickers, actually the pimps really, the local pimps, are very often of the same community as the bought and sold people. I'm not here defending pimps, but actually, you know, they are. The real problem here is the buyers, you know, the ones with the power, the ones with the money. And they, so, the idea of prostitution is that when you pay someone for sex, that means then you have, quote, consenting adults. And my thought is that the money is a form of force. It is not an expression of consent. And the people in prostitution are overwhelmingly destitute, and they don't have other options. And if they did, they would be doing them. And when they survive, and you got to leave to survive. People who are still in prostitution have not survived prostitution, right? It's hard to leave, and you do it many times. And it's like battering, exactly, actually. And so, the international law on sex trafficking is very clear that consent is not a defense. And that includes consent by other people. Sometimes desperate families sell their children to traffickers. That doesn't mean the children consented. Then they grow up and they have no education, no job training. They're often addicted to drugs. Their only community is the brothel and that, or the street. Usually, often it's house, but it works the same either way. And the fact that they don't leave doesn't mean they are consenting to what is being done to them. And that it is legal doesn't mean they are consenting to what is done to them. But if it is said that that is what consent looks like, the laws around it, so long as there's force or fraud or coercion, says that consent is not a defense. And I'm fascinated that, if you're in prostitution, if there's force, fraud, or coercion, consent isn't a defense. But if you're not in prostitution, there can be force, and consent is a defense. So now we've got two whole sets of laws, one for people in prostitution and one for people outside? Really? It's this is insanity. These are like things people just don't connect the dots. And, since, again, pornography is a form of that, and calling it empowerment is like a lie. It is trying to make people feel better about using it and being in it. I think, too, that some people who are in it are thinking that they have more power than when they weren't getting paid. And they're thinking that if they think they chose it, that someday they can choose to leave. I think that's part of, at least I'm told this on good authority. People who are in it are people who have been in it and no longer are in it. And at this, but seeing that the power was a fantasy, an illusion, something that allowed them to get through it, along with everything else they had to do to get through it, and that the choice idea simply meant that virtually 90+% of their choices were precluded, and then she's found doing this one thing, and that gets called her choice, which is a debased notion of freedom, certainly, which choice is standing in for.
Thank you.
Okay, thank you. Go ahead.
Hi, I'm Charlotte.
Hi, Charlotte.
I want to start just saying thank you so much.
Oh, you're so welcome.
Quick disclaimer, I read your book only words 6 years ago, and I started working in sexual violence prevention 6 years ago.
Oh, wow.
So to say I owe a lot to you is a massive understatement. Cool. But my question is mainly about how prevention work would be working with a law that's more surrounding welcomeness. So on a small scale, thinking about colleges like Brown, most schools have a Title IX office and a prevention group. that's more focused on sexual violence education. And right now, what I've noticed, at least in the last 2 years, is a lot of the groups that do prevention are coming in after having a few Title IX cases and are then asking questions that are mainly surrounding preventing being accused versus preventing sexual assault. So there's this kind of weird period we're in, I think, where there's very little overlap with Title IX and the people that are doing education. And I was wondering, I guess, how you would think about instead of if Title IX is maybe focused more on willingness and prevention work is more focused on welcomeness, how your approach would then bridge those, and if that can be bridged, and if you think, I don't know, if prevention.
Well, I think it can. If somebody's, if there is really welcomeness there, you don't have a willingness problem. I mean, welcomeness is way more expansive.
So, but in, like, I guess what I'm thinking is, like, in the last 2 years, if we're working with, say, like a couple weeks ago, we had a group of 70 men on a sports team. So if we're working with that type of group, and, you know, half the questions are mainly about, like, you know, the number of drinks or the number of
Okay,
XYZ.
look, I would start talking to them about entitlement. I seriously would.
Yeah.
It's like, you know, do you have the idea that getting some is, you know, something you're entitled to have?
Mm-hmm.
Forget it. You're not. All right? Nobody is entitled to anybody else's body. And, you know, and also, you know, these interactions are equally up to both of you or whatever, you know, if there's more than two of you. But it's equally up to everyone. And, you know, I think, you know, you really get the feeling that men have never had sex with a woman who really wanted to have sex with them. Seriously. I mean, like, they don't know what enthusiasm looks like. And therefore, there's just this, you know, how am I going to get some if I'm going to have to do it this way? And, I mean, it's sort of like dealing with pornography. Always the question has been, what can we still have? You know, now that you've said this is what it is and this is what it does. And I guess I would just start with talking about masculinity. You know, actually having sort of taught the first women's studies course at Yale in, I don't know when, I was in law school. It must have been 75 or something. And did women's studies, you know, for like a long time. And I sort of did it for 40-some years. I thought I was doing it. One morning I woke up and I thought, I've been studying men this whole time. And, you know, and it's, I mean, everything else is men's studies, but they don't study men as men. I do, you know. It's a whole different thing. And, you know, so I don't know if I was going to talk to 70 men on a, you know, what team is not football?
I can't say that,
okay,
but
whatever.
I can tell you later.
I mean, it's like, what is with football? But there's this great book called The Stronger Women Get, the More Men Love Football, which is a great title of a book. But I really would start with masculinity and the sense of entitlement to sex, which they're not entitled to. You know, that, you know, intimacy with another person is like something sort of precious and special, and, you know, or, you know, it's at the very least mutual, whether it's intimate or not, in an interpersonal way. And I think, you know, instead of thinking in terms of consent, start talking in terms of equality and see what happens. That's what I would do.
All right, thanks.
Yes.
Thank you for hanging in there with me.
Oh, you're welcome.
Walter Harper, alum. I'd like to ask you a question. As a lawyer and as an advocate, how would you go about educating the nation in terms of the upcoming trial with Mr. Trump and the woman accusing him of rape in New York City?
Oh, that's a good one. I am really looking forward to her and her defamation case, where he said she was lying when she said that he raped her. Okay. I think she has her panties from then. And this is E. Jean Carroll. And I think he's going to do everything he can not to get to trial, because when you get to real evidence, there well could be a DNA match in there. It's just he's going to have to provide it. So I hear that he is very focused on that particular case, as opposed to his attempts to bring down this country on January 6th, which he just keeps blowing off. He's not blowing off E. Jean Carroll's lawsuit. So I think she has a real chance, and I'm rooting for her.
Okay.
What do you think?
I think that, just like you, my concern is the nation regarding this particular issue. They're not lucky enough to be at a place like Brown University, or maybe have the opportunity to have a formal education where they realize that for this particular issue is more than just what you might think. There's a whole body of knowledge that can better inform you in terms of how you can either judge this or take a position.
Right. I mean, the fact that he said she lied means that he doesn't have the defense of saying it was mutual.
Right.
Whatever. That she wanted to have sex with him in that changing room while she was advising him on something he was going to buy for one of his girlfriends.
Right.
Which is what they were doing. And she was a gossip columnist and had written about him, and before, and he recognized her, she recognized him, and they just started talking in the store. And I think that it has a real chance of showing of a finding that not only is he a rapist, but he's a liar. And he lied when he said she lied about it. And to me, that's a really important double-barreled finding. And, I think it has real possibilities of educating the nation all on its own. I do.
Thank you so much.
Yeah, thank you. Thanks for bringing it up. Go ahead.
Hello. Thank you.
Sure.
I was wondering if your sort of conception of welcoming changes sort of based on the situation or why people are having sex. So, is to welcome somebody just to have sex different from, to welcome somebody to have sex, to have children, for example? Would you describe a difference between those two
I wouldn't say they're
situations?
different, no. I mean, if you want to be having sex in order to have children, but you welcome it, then you do. It's like, hey, honey, I think it's such and so time in my cycle, and I just did this test, and my temperature is whatever. So how about in the next 3 days, let's give it a shot. And hopefully, something good happens between them, but they're doing something together. It's mutual then.
Thank you.
Yeah.
Hi, sorry to stand up right at the end, but I'm curious about, you're a lawyer. What do you think about how sometimes I think people look to the law as an arbiter of right and wrong on this? I'm thinking about the Amber Heard trial, if you followed
That was
it.
ghastly.
Yeah, and how it wasn't
They made pornography out of her, and she never got out of it. And I don't think her lawyers understood that at all.
Yeah, And I think it's crazy that it was not a sexual assault suit. It was like a defamation suit, and like she's not allowed to call herself.
No,
a
but they
victim of
started
abuse,
out
but-
with she's bisexual, she blah, blah, blah. And, you know, she's pretty and she's blonde and the whole bit. And, you know, I mean, they made pornography out of her, in effect. And it, also the people who supported her have continued to be completely abused online. And trolled like crazy and lied about and threatened. Still, I mean, the whole Johnny Depp thing is astounding to me. I'm used to seeing people shred women. What I'm less used to, actually, they kind of backed off when it turned out he can't get it up, apparently, but that like dampened the enthusiasm of his supporters considerably. But up to that point, you know, it's just amazing to me. And also all the evidence that she had and and the fact that she won in the UK, which is like twice as hard in a defamation case as it is in this country. On the, on her side of it.
Do you think that
she has to prove what she said is true? Here, you only have to prove what he said is false. I mean, it's really different. And she did prove it was true there. I'm sorry, go ahead.
I mean, I was just curious, like, do you think that it means that we're like valuing incorrect court judgments too highly, or like misconstruing them as like a form of like truth? I mean, especially because like there's a lot of talk about post Me Too with her. Like,
no, it's a good point. And a lot of people, interestingly, with Me Too, instead of going to courts, are going to the press, which never happened before. Never. In fact, there's big studies on this, that the reason women don't report crimes against them is fear of the press, generally. That's been the case for decades. And Me Too just did a complete reverse. I have a lot of women contact me who say, you know, this happened to me, et cetera, you know, what are my chances in court, or should I just go straight to the press? Wow. This is new. Yeah, I mean, I think people do have, a lot of people generally have a well-founded skepticism like yours, that courts may not be, you know, certainly the only, maybe not even the ultimate arbiters of what happened. And they're critical of when they think something happened and a court found that it didn't. Or the court found that it did, and there's a jury that made a decision, and there's a lot of criticism of that. People do that all the time. And, you know, I think that's healthy. I think it's good. It's right. People should do that. Isn't that I think they're always right, or that anybody's necessarily always right, but you really are entitled to have your own view of what's right, I think. And, you know, one of the things, though, about court situations is that often people are not aware of all of the evidence, and the people who made the decision, like the jury say, is. And they can be wrong, for sure, but they also do have more exposure, you know, to all of the evidence, unlike with Amber Heard, you know, where they did wall-to-wall coverage of the thing. But people didn't watch it all either. They watched it selectively, it turns out. But I think in this country courts are given a lot of credit, and it's, you know, I think it's good to have a skepticism that you're expressing that's not always, you know, is certainly not always is justice served, and certainly not always is the right thing done.
Thank you.
Mm-hmm. Thank you.